no unilateral grabbing of land, no more politics of appeasement, and definitely no politics of fear-mongering. The Supreme Court's order on the Waqf law has been interpreted as a win by all sides involved, but the facts say something else. And the facts are especially important in election season, given that this Waqf law was used to claim that the party in government is actively victimizing and othering Muslims, and the Waqf law was nothing more than an attempt to snatch their land. But if one actually reads the fine print of the Supreme Court order, the court refused to stay the law. It also has passed an interim stay on only 3 contentious clauses. What is the most important part of this order is what has been glossed over. The most important part is that the apex court upheld the deletion of Waqf by user, saying that if the legislature finds examples of the misuse of Waqf by user, then it is justified in deleting that provision. And it is this that goes at the very heart of the reasons why the law had been brought in the first place. Numerous cases that we had highlighted where land was deemed as Waqf purely by virtue of being under Waqf use and hence Waqf by user. We told you stories of how farmers, temple land, all of it was deemed Waqf by user and taken away from its actual owners, of how people discovered in retrospect that land for which they had the papers was suddenly under Waqf control. Why? Waqf by user. The removal of that provision of Waqf by user has now been upheld by the apex court, and that is why now the government is claiming that those who were engaging in politics of land grab, of fear-mongering, now stand exposed.
The opposition was all these days, they were saying that the Waqf amendment is unconstitutional. But the court has upheld that amendment. And they have said that there is nothing unconstitutional in that. Many of the provisions of the Waqf amendment has been upheld. And Supreme Court has accepted the necessity of reforms in Waqf Act. The acts, transparency, the development of the Waqf properties, digitization, all these are upheld by the Supreme Court. What the opposition is trying to tom-tom and saying that it is a setback for the government, the fact is those who went to the court didn't really get what they wanted.
इसमें जो कमेटी बनी थी इस बिल के ऊपर चर्चा करने के लिए, उसका मैं सदस्य भी था और तब भी हमने यही बात कही थी कि आप ऐसे संशोधन मत लाइए जो कि व्यवहारिक ना हो। और हमने कमेटी के अंदर भी सवाल उठाया था कि भाई आप जो है वो अपने दोस्तों को ये धार्मिक संपत्तियां देना चाहते हैं वक्फ की, इसके मकसद से ये बिल ला रहे हैं। बहरहाल तब हमारी बात नहीं सुनी गई, संसद का भी समय बर्बाद किया गया, वो कमेटी बना के भी समय बर्बाद किया गया और जबरन जो है एक गैर संवैधानिक बिल पास किया गया। हम लोग पहले दिन से कह रहे हैं कि भाई ये बिल पूरी तरीके से गैर संवैधानिक है। क्यों है? क्योंकि आपने वक्फ बाय यूजर रद्द करने का जो फैसला है वो कलेक्टर के हाथ में दे दिया। आज सुप्रीम कोर्ट ने उस पर रोक लगा दी। कलेक्टर किसका होता है? सरकार का होता है।
ये जो इंटरिम ऑर्डर आया है, इससे जो कानून मोदी सरकार ने बनाया है, मोदी गवर्नमेंट ने बनाया है, एनडीए ने बनाया है, इससे वक्फ प्रॉपर्टीज का तहफ्फुज नहीं होगा, प्रोटेक्शन नहीं होगा और एंक्रोचर्स को रिवॉर्ड किया जाएगा। वक्फ प्रॉपर्टीज में कोई डेवलपमेंट नहीं आएगा। तो इसीलिए हम उम्मीद करते हैं कि सुप्रीम कोर्ट जल्द से जल्द एक फाइनल डिसीजन लेने के लिए जो भी जरूरी इक़दाम करना है वो सुप्रीम कोर्ट करे।
The opposition parties are the people who are feeling it as a slap. Should understand it is only an interim order and that too a partial interim order. The act has not been stayed. Only some provisions in the act were stayed. Overall, the intention of the government in bringing the act is not been stayed. It is not a final judgment, it is only a partial judgment. So therefore, there is nothing for any party to celebrate or be jubilant, and should not feel that it is a slap on the government.
All right, and that brings us to the big questions today, on which the buck stops here with the scrapping of Waqf by user upheld. Will this spell an end to the politics of land grab? Joining us now on the debate, we have Nalin Kohli, national spokesperson of the BJP, Dr. Syed Nasir Hussain, Rajya Sabha MP of the Congress, Shadab Chauhan, leader of the AIMI. But my first question is to you, Tushar Gupta, political analyst, because a lot of people are focusing on Waqf by user and the fact that registration of property has been upheld by the Supreme Court. The Supreme Court has said you must have registered land. Why is that so important? There are other 3 clauses which were problematic, which have got an interim stay. Why not focus on that instead?
Let's go point by point, Padmaja. In 2013, when the amendments were brought in by the outgoing Congress government, there were 2 provisions, Section 40 and Waqf by user. The Waqf by user was introduced by the Nehru government around 1950s. But Waqf by user said that if the Waqf deems that this property or this land parcel was once used for pious purpose, they can claim it as their own. What allowed them to make that claim? Section 40. But the definition of who could make a waqf was altered to also include non-Muslims. Now, this was the important point. Section 40 and waqf by user got their entire, usage, their utility from the definition of who could make a waqf. Section 40 is gone, waqf by user is gone. For those people who still have a confusion, the judgment of the Supreme Court, page 85, point number 147 to 150, the Supreme Court clearly says that even before the 2025 amendments were brought in by the Modi government, the Waqf board had an opportunity for almost 100 years to register the property. And if they could not submit the deed under the previous acts, there was an option for an application to be made. So if these people have not made an application or registered through the process prior defined for almost a century, they are not going to claim any unregistered property as their own. Point number 2, and very important. Okay. In the 2025 amendments, the Modi government had installed an important point. It said all those Waqf by user properties which are registered before the commencement of the act will continue to be registered Waqf properties. Now, the problem is most of these properties are not registered. They are verbal declarations, which is where Section 40 and Waqf by user became important. Now, both are gone. The registered properties are only going to be valid, but the problem is most of them are not registered. And that is what Amit Shah said. That is what Amit Shah said in the parliament. Yeah. That you until 1913 to 2013, you had 18 lakh properties, but between 2013 and 2025, an increase of 21 lakh. Waqf by user and Section 40. Okay, Dr. Syed Nasir Hussain, and this really sums up the main problem that people were facing. That their lands, in many cases, farmers' lands, in Karnataka, in Tamil Nadu, in Uttar Pradesh, was deemed Waqf property. How? Waqf by user. Even if it hadn't been registered. Now that arbitrariness has been done away with and the court has upheld it, don't you think that really goes to the very heart of what the problem of the Waqf issue was?
Padmaja, 2 things. One, let me first correct what Mr. Tushar Gupta has said, that Mr. Nehru's government used the term Waqf by user. He should understand it was not Nehru's government or somebody else's government who used this word. It was a judicially developed phrase that was used by courts in different categories. Waqf board never used or coined this word Waqf by user. This was used by courts. Let him understand that first. Number 2, you are saying that all these properties which were Waqf by users will go away. The court has clearly mentioned that Waqf by user will be implemented prospectively. That means till now, whatever Waqf by user properties are registered or existing, they will be there. Hereafter, there will be no Waqf by user property. Point number 1. If you remember my parliament speech, I had made it very clear. Hundreds, 200, 300, 500, 1,000 years back, there were many religious institutions of Muslim community which were given dan by various Rajas, Maharajas and also by kings. that property is worked by user, and that too because a masjid is available there, or a dargah is available there, or a kabristan exists there, or a Eidgah exists there. That is the reason why I say we don't have records, but the property exists there, and there is religious activity happening there. So that is work by user. That was given by someone, but no documents were there. So now the court says prospectively this will be there. Point number one. Only thing there is no clarity in this. What will happen to all those cases that are already there in the cases? Large number of work by user cases already there. There is no clarity on that. I wish there will be more clarity on that when there is a final order.
No, but Dr.
Point
Hussain,
number 3.
Dr. Hussain,
See,
if I may.
The most important thing to me. No, Padmaja,
okay,
let me finish. Padmaja,
yes.
let me finish. See, the most important stay in yesterday's interim order is that disallowing the collector to have his say. That was the crux of the problem, because that would have created hundreds of Ayodhya-like problems, thousands of Ayodhya-like problems in the country. That is where the stay is. I think that is where exactly they have stopped the ill intent of this government.
Okay, fair. The powers of the collector has been curbed, but I again bring you back to Waqf by user. The question wasn't about, and Nalin Kohli can come in on this, the question wasn't, Dr. Hussain, about where somebody has willingly donated land. It is where land which does not belong to you has been deemed as Waqf because it is being used as a Waqf property. Now, what did the Supreme Court say about it?
Padmaja,
The Supreme Court said, sir, if I can just read out what the Supreme Court has said,
Padmaja,
sir, on this specific issue, the Supreme Court observed.
Padmaja, give me 10 seconds on this.
So just a second, I just want to read out what the Supreme Court has written.
10 seconds on this.
I will give you 10 seconds. In any case, to do charity, a person will have to do charity of his own property. So yes, a Raja owns the property, he can donate it. But nobody can come and say this agricultural land, because it is being used as Waqf property, turns into Waqf property. It can't be Waqf by user. Will have to do charity of his own property or the money owned by him. A charity cannot be done by a person of a property or money owned by a third person or a property owned by the government. In that view of the matter, we are of the prima facie view that such a requirement cannot be held to be arbitrary. That is, scrapping of Waqf by user cannot be held to be arbitrary. You cannot take over government land, agricultural land, temple land and say it's being used as Waqf, so it is Waqf by user. Dr. Nasir Hussain.
Then, Padmaja, point number one, you give me one case in the entire country which the Waqf board has claimed that it is Waqf board's land. I'll tell you where the problem lies. I said this in my parliament speech, I said this in JPC, I said this in n number of TV debates. See, this land was not, this land was given by someone or the other at some point of the time. There are partial documents for that. But when there were land reforms in Karnataka, when there were various land ceiling act was there, land redistribution policies came in various states, then these lands were given to.
No, Dr. Hussain, with the greatest of respect, I can quote to you multiple examples, but I will leave it to Nalin Kohli. In Tamil Nadu, an entire village which was taken over as Waqf land. In Uttar Pradesh, in Bihar, where land which belonged to villagers has been deemed as Waqf land.
No, what is this? You're not allowing me to speak.
Padmaja, if I can now...
Sir, you have spoken. You have asked for examples. Okay, let Nalin Kohli come in and give examples.
Let me finish, Padmaja.
Okay, sir, only 10 more seconds because Nalin Kohli and Shadab Chauhan are waiting.
I'm waiting for 10 minutes.
Yeah, 10 more seconds. See,
only 10 more seconds.
I don't agree with that.
Only 10 more seconds.
I have a counter view.
The point is, when these lands were taken away by various state governments through various acts. After that, there was a Supreme Court judgment which said once a Waqf is always a Waqf. Basing on the judgment, some of them went to the court.
Okay, Nalin Kohli countering now. Nalin Kohli countering now.
The Waqf board which was given to farmer by various acts.
Okay, Nalin Kohli, is it as simple as that?
Pause for a minute, no?
Nalin Kohli.
No, it's not. It's not as simple as that. And I don't agree with the points being made. Yeah, I have a counterpoint. And I will have to respectfully point out that I'm a practicing senior advocate at courts and we must look at this with a little bit falling backwards. What was the first charge against the Modi government when this act came, or these amendments came? That essentially The whole, I think, is to undo the Waqf. It is not to undo the Waqf. Please, let's start from the top. India is not a religious country. It's a secular country. It runs by the constitution. Now, under the constitution, you will have rights. Nobody can have rights over one or the other. Article 14 will step in. Now, if Nasir Saab says that these lands were donated to the Waqf, prior to the advent of Islam in the 17th century, all the land belonged to the temples. So, I mean, where are you going to draw the line? Can we go 5,000 years, 4,000 years, 3,000 years? We can't. So, therefore, when you run on the constitution, you run on rule of law. Now, what is the situation here? The court has held that if 102 years have passed since the 1923 Act of the Waqf, subsequently even the 65 or the later amendments, somewhere somebody in the Waqf management should have gone and registered the land or pointed out that this is our land. Nobody does that. What you have a situation, one person wakes up, says that this land belongs to the Waqf. Now that land could belong to a farmer in today's rights, in the revenue records, may belong to a temple, may belong to a village, may belong to XYZ. You can't say I am a user on it and hence I am owning this rights and undo the rights of land of some other person which is constitutionally protected. That is why the Waqf by user was the most important factor.
Okay.
The DM's power in terms of saying it should not be arbitrarily loose is the Supreme Court's coming in and saying, no, you must do everything in a reasonable way. So the first question to come is, are the Waqfs functioning perfectly? No. If they were functioning perfectly, all the records would have been up to date.
No, so let's settle this Waqf by user. Dr. Nasir Hussain is disagreeing with your interpretation of the court order. Nalin Kohli, quick rebuttal, then I must bring in Shadab Chauhan.
There are three people on this channel. No, I must finish my point.
Okay, finish your point. 20 seconds, but Waqf by user, we want to settle that issue first.
No, I must. It can't be 20 seconds because I have heard that 10 seconds, which was 2 minutes. I'm sure Nasir Saab would have more to add. I want to finish my point, that's all. My point is as simple as this, that if something is precious to you, whether it has come in a religious endowment or whether it has come in a purchase, you will make sure that your records on it are right. If you have not made your records, you had ample opportunity between 1923 when the act came in and subsequent decades for you to make sure. You don't do that and you suddenly turn up and say, I am a user and say that. This was the most contentious issue and the Supreme Court has completely rejected that argument. So to say that the government has faced the flag is incorrect. The Supreme Court has held, the Honorable Chief Justice of India, Justice Gawai's court has held that the act is constitutionally valid.
Okay.
It has only gone ahead. It has first rejected the argument that the Waqf by user which was removed or amended was incorrect. It is constitutionally correct. Second, they will need to register their lands. They will need to give full details so that in the future there is no such problem.
Dr. Nasir
What
Hussain.
it has simply done is curtailed the power subject to some further.
And since you asked about examples where the Waqf has unilaterally taken it over, let me quote to you two of the most popular examples that have been brought up even in parliamentary debates where you were present. One is the village Teruchenturai in Tamil Nadu, where you had an entire village that was declared Waqf, and it was brought to light when a man chose to sell his or tried to sell his agricultural land. Then you got the example of an entire village in Govindpur. You're saying that's not the case. That village which has a temple also, including the land on which the temple stood, was declared Waqf land.
Padmaja, I'll challenge you on this television channel today. If you can prove somewhere if the Waqf board of Tamil Nadu has claimed that village as its own village. It was wrongly entered by a Sheristidar, which was corrected by the principal secretary. The principal secretary accepted this in JPC. Principal secretary, revenue secretary, DC came to JPC and said, Waqf board never claimed that village as its own. It was wrongly entered by the Sheristidar. Please check up the
Govindpur village? Govindpur village in Bihar?
Don't spread these
Okay, it is wrong interpretation, Tushar Gupta. Wrong interpretation. Okay, you are saying that this has been completely misrepresented because it was quoted inside Parliament, sir. This particular example.
Don't spread lies on your channel.
No, I am not spreading lies, sir. This was given as a factual example on the floor of the Parliament.
My
you
simple
correct your
fact is,
facts.
Padmaja,
Then you
if the
correct your
Waqf
facts.
has
I have
not
said on
claimed
the
any
floor of the
property
House.
unilaterally,
I have said this
how
on the
has
floor
the
of the House.
area under the Waqf gone up by 21 lakh acres in the last 11 years? Point number two, to the Congress MP, May 24th, 1954,
can I-
Gazetted Authority has published the Act, Section 3L2. It says Waqf by user properties will be included. Point number three, again, your government in the past introduced the Section 40. It sustained Section 40. It changed the definition of who could make a Waqf. It allowed Section 40 to exist, and that is how properties were being claimed unilaterally. It's fine to say, oh, it was a mistake, it was not meant to be. But the truth is, properties went up by 21 lakh acre in just 10 years.
Okay.
Padmaja, can
Dr.
I
Hussain. Dr. Hussain.
Padmaja, I want to answer this.
Answer.
Yeah. See, I want to answer this political analyst who is pro-BJP and pro-government to correct his facts. For the first time, entries and digitalization and registration came in 2013 amendment. And 2014 BJP government came in. And Mukhtar Abbas Naqvi somewhere in 23 said that 100% registration has been done. So this rise in registration was during BJP's period. If this was fake entries, if this was fake occupation of lands, what was the BJP doing? There were no entries before 2013 because there was no registration process, there was no digitization, there was no portal. Portal came only after 2013 amendment. So if this person doesn't have the right, right data with him, let him not spread the false things on the television channel.
No. Okay.
Mukhtar Abbas Naqvi on the floor of the House, the Union Minister for Minorities had claimed that 100% registration was done during BJP's period.
Okay, and since you have said that factually the example of Tiruchenturai is inaccurate, even though I repeat, this was quoted in Parliament as an
100%.
example of
I'll
when
prove
land
that.
has been unilaterally taken over. Let me quote to you 4 more examples, sir. Example number 2, Govindpur in Bihar.
Again you are wrong. Again you are wrong.
Sir, let me at least quote the example.
We have corrected this in Parliament. Again you are wrong.
Okay,
Again
let me
you
at
are
least
wrong.
quote the example, sir,
You are
before
wrong.
you declare them wrong.
We have corrected this. We have pledged it in the Parliament that this was a wrong narrative.
It is not a narrative.
This is a wrong narrative.
Sir, these are
Nobody
people
in
who
this
are on
Tamil Nadu
record,
wants
Dr.
them
Nasir
that
Hussain.
village as its own.
These are
Nobody-
people who are on
nobody
record
said.
saying that
give me
our
the
land has
papers.
been taken. Can I
You
please
give
at
me
least
the-
name them?
You give me the papers if Tamil Nadu Waqf Board has claimed that village.
Sir,
Give
can
me
I
the papers.
name the examples?
I will give you the report of
Govindpur.
JPC.
Sir,
You
can I
please
name
check
the
report of
examples?
JPC, what is
Govindpur in
Can you
Bihar.
please-
In August
please check the
2024,
report of JPC,
the Sunni
what
Waqf Board
the
said
secretary has said,
that the
what the
entire
revenue secretary
village
has said.
belongs to us.
No,
7
no, no.
families
Can I
were
make-
told to leave
You are
that
neither
village.
part of Waqf Board.
Sir, I am reading
can I-
newspaper
administration.
reports.
Please don't.
I am
spread
reading
lies
news-
here on the
Wrong.
channel.
Fact check.
Don't
Fact
peddle fake
check.
narrative here.
This is
Don't
not a
peddle fake narrative.
Okay, at least let me read out the newspaper reports,
it's fake narrative
and then you
by
can
you,
put your
Padmaja.
point. In
It is
Kerala,
fake narrative
are you
by
saying
you on
even
the
the
television
Kerala
channel.
example is wrong? In Kerala, 600 Christian families in Ernakulam are contesting
do
the
you know-
Waqf
do you
Board's
know what
claim
happened in
over their
Kerala?
ancestral
Do you know
land.
what happened in
They
Kerala?
appeared before you in the
Do
JPC.
you know what happened? Nani, do you know what happened in Kerala? Do you know what? I'll explain what happened in Kerala. There also, it was the Kerala High Court which passed strictures saying that it's a Waqf property and moved a contempt case against the Waqf Board to register it as a Waqf property. Do you know that? When you don't know the facts, why are you speaking?
Okay,
And
so
spreading comments here?
examples that are
You
given
don't know
are
the
part
facts.
of a false narrative.
In Kerala, it was the High Court which said it's a Waqf property.
Okay,
And the
quickly
petitioner
respond to this,
was
Tushar
not the
Gupta, then I want to
Kerala
go across to
Waqf
Shadab
Board.
Chauhan.
The
No,
petitioner was
the
an
Congress
individual person.
30
MP, the
seconds.
Honorable Congress MP just said that all the properties have attained 100% registration as has been claimed by one of the BJP ministers. My simple question then is, why did one of the lawyers representing the petitioners said to the Supreme Court that there would be no deeds available, the paperwork will not be available for some of the Waqf properties? Can the Congress MP today certify on national television on your show that of the 39 lakh acre property under the Waqf, all of them are registered? And if they were registered, what was the problem with the amendments in the first place? And number two, Padmaja, for the sake of clarity, I must read out this specific point from the Supreme Court judgment, which says, point 147, we are therefore of the view that if the Mutwalis for a period of 102 years could not get the Waqf registered as required under the earlier provisions, they cannot claim that they be allowed to continue with the Waqf even if they are not registered. This is directly from the Supreme Court. This is quoting directly from the Supreme Court judgment. I don't know where the confusion is.
Okay, before you respond, Dr. Hussain, I want to bring in Shadab Chauhan. Shadab Chauhan, I think the only outlier in this entire debate is the AIMIM. Every side is saying they are vindicated. AIMIM, the only one which is saying that this actually is a setback. Why?
The reason behind is that from the day when we are opposing this draconian law, the main agenda of the government is to snatch our properties and give them to their friends like Adani, Ambani and such like that. The setback, we are saying that it's just an interim order. We are looking for a final order. How we can say that ASI, how can ASI will be the owner of the property of my masjid, especially if any masjid is a protected monument which is under ASI, how we lost our ownership?
No, you will not lose your ownership, sir. Shadab साहब, यहाँ पे सिर्फ इतना कहा गया, आपके पास रजिस्टर्ड जो है वो आप ही के पास रहेगा. जो रजिस्ट्री नहीं है, वो आप क्लेम नहीं कर सकते ना.
Padamja, we just want to ask that Section 3D was put at the last time in the Parliament. Why? What's the reason? Section 3D were not discussed in the JPC. They put at the last moment. How we can say that if the ASI is the protectee of any particular movement and there is a masjid, there is a mosque, and till right now the Waqf board is not the owner of the property.
Okay, Mr. Chauhan, with the greatest of respect, now again, if we are going to have a clause-by-clause discussion, that has happened in the JPC 1 and the law hasn't been stayed. So if you have a problem with every clause, that is sort of a ship that has sailed because the Supreme Court right now has refused to stay the law. And you have problem with all the clauses of the law, nothing can be done about that now. Dr. Hussain, do you want to respond? Just a second, Dr. Hussain, then I want to go to Nalin Kohli.
Let me answer Tushar. He says that these properties were not registered. I am again and again telling there are two angles to it. One, the BJP former minister claimed that all properties have been registered. That means they have been registered somewhere, registered with document, somewhere registered without document because they were Waqf by user. Now the court has said, you should understand this, Mr. Tushar Gupta, the court has said that this is Waqf by user prospectively. In the sense, till now, whatever Waqf by users have been included in the portal of Union government, they will be there as Waqf by user even if they don't have documents. But just hold on. Hereafter, there will be no fresh by user. There will be no fresh Waqf by user. That is what they have mentioned. It was mentioned in JPT also. It is mentioned here also. Be very clear about it.
Dr. Hussain, we are not talking about the registered properties. We are talking about the unregistered properties. If the properties, all of them were registered, why go to the court in the first place?
You asked about the registered property. I am saying whatever registered have been, they will be there.
But what about the ones that are not registered? That is what the amendments changed, that all the properties that are registered before the commencement of the act continue to be the properties. That is what the government is also saying. The question here is of unregistered properties. Please do not miss the question.
Mr. Tushar, the grey area here is what will happen to all those Waqf by user properties that are there under dispute in various courts. That is the grey area.
Are they registered or not?
Anyway, this
Sir,
is
if they are unregistered, the Supreme Court is very clear.
Final order has to come.
That is what I just read out for you.
When the court has
Supreme Court is
accepted
very
this
clear on unregistered properties. They cannot be further claimed as Waqf properties. The Supreme Court is very clear on unregistered properties. They cannot be claimed further as Waqf properties. This is from the Supreme Court. This is not an opinion. It's in the judgment.
Okay, Nalin Kohli, Nasir Hussain is saying that this is a narrative that you're trying to build about arbitrariness and takeover of land. That has never happened, and all those individual cases have been addressed in courts of law.
That's a very easy argument. If it's never happened, then why are they so worried about this law? And then it was something to celebrate and thank the government for bringing the law. हमने तो कुछ गलत किया नहीं, कोई किसी के पास गलत नोटिस नहीं किया, किसी की जमीन हमने क्लेम नहीं किया एज अंडर वक्फ बाय यूजर, तो हमें क्या टेंशन है? We have always done everything right, all the papers are right, all the waqfs are managed well, there is no problem. Simple. Then why this contentious fight? Obviously it was not the case. Because it was not the case and these kind of cases were coming up where some person got up and tried to take over the waqf take over others' lands in the name of the waqf, it led to a hue and cry, and quite correctly. The constitution provides protection to every citizen of India. No one can claim and say that my right under whatever religious denomination is going to be greater than the right of another person who owns land. Quite logically, the biggest problem was the encroachment of government land. And encroachment of a government land is a reality of India. Take the case of Assam. Illegal immigrants from Bangladesh have taken over thousands of hectares. Now the chief minister there, under an exercise, Dr. Himanta Biswa Sarma, is clearing out those lands. They include the temple lands, the Shatro lands, all of those jungle lands. It is illegal takeover. In the same way, government lands or forest lands or other lands or community lands are targeted because lands have become very priceless today. In terms of economic value, population has grown, there is a demand and pressure on land.
Okay.
It is to protect lands. Nobody wants to take the lands which are legitimate lands of the Waqf. They are entitled to their lands, they are entitled to those protection, but certainly somebody can't stand up and take or claim a right on somebody else's land invoking the Waqf.
And
by
on
user
that,
clause.
I think the Supreme
So
Court is also
very
absolutely
good
clear. If you actually read the entire judgment on the issue of arbitrary takeover, of registration, of people having the right to give their land to Waqf or otherwise, provided they own the land, the order is crystal clear. More often than not, perhaps, it's the interpretation that is political. I'm afraid, sirs, I'm completely out of time. Remember, this is an interim stay. We'll wait for greater clarity. For the time being, on the issue of whether Waqf by user is accepted, the buck stops here. Thanks for watching.